Hello friends, good afternoon and welcome to our EduSat network. Our topic of discussion is part of our series on Indian Judiciary, and the specific topic for today friends is the jurisdiction of the Supreme Court. And for this very discussion we have with us in our studio Dr. Rakesh Kumar, Assistant Professor of Law, the School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. Dr. Kumar has been teaching for more than a decade friends, and with this introduction I would like to welcome sir. Thank you so much sir for coming.
Thank you, Urvashi. Good morning, listeners. On my previous lectures on Indian Judiciary, in my first lectures, I have given you the brief idea about the hierarchy of the Indian Court along with the appointment of judges of the Supreme Court and all the controversy which has surrounded regarding the appointment of judges of the Supreme Court and High Court. On my second lectures, I started with the contempt of court jurisdictions. Along with that, I started with the jurisdictions of the Supreme Court. As a part of jurisdiction of the Supreme Court, I have covered up to Article 131 of the Constitutions, and I have given you the brief idea about the Article 132 of the Constitution. Just for the sake of continuity, I am starting with the Article 132 of the Constitutions. And if you see the Article 132 of the Indian Constitutions, it provides for the appellate jurisdictions of the Supreme Court in with respect to the constitutional matter. And if you see the verbatums of the Article 132 of the Constitution, it says that the appeal shall lie in the Supreme Court from any judgment, decree or final order of the High Court in the territory of India, whether in a civil, criminal or other proceedings, if a High Court certify under Article 134A that the case involves a substantial questions of law as to interpretation of the constitutions. So, as far as the jurisdictions of the appellate jurisdiction of the Supreme Court under Article 132 of the Article 132 of the Constitution is concerned with respect to the any of the judgment which was given by the High Court in the civil, criminal, other proceedings, and if the High Court certify under Article 134A that the case involves substantial questions of law as to interpretation of the constitutions, then such case may be admitted before the Supreme Court in appellate jurisdictions under Article 132 of the Constitution. And if you see the provisions of the clause 3 of Article 132, it says that where such certificate has been given, then any party to the case may appeal to the Supreme Court on the ground that any such questions as aforesaid has been wrongly decided. So, first you have to keep in mind that how the appellate jurisdiction of the Supreme Court was being regulated by the introductions of Article 134A of the Constitutions. Article 134A was being added by the Constitution's 44th Amendment Act, and the basic object of Article 134A is to avoid delay in granting certificate by the High Court for appeal to the Supreme Court. So, under Article 134 is concerned, here the High Court can grant a certificate for appeal to the Supreme Court under Article 132 either on its own motions or on the oral applications of the aggrieved party immediately after passing the judgment, decree or the final order. So, the moment the court has pronounced the judgment, and if the request is being made by the aggrieved party to the case, then that case the court will be the High Court will be under the obligations to decide as to whether this is a case where the appeal certificate of fitness may be granted. So, the aggrieved party can approach the Supreme Court under Article 132 of the Constitution with respect to the interpretations of the substantial questions of law as to the interpretation of the Constitutions. Now, come to the essential requirement of Article 132 of the Constitution. As far as the applicability of Article 132 is concerned, here the certain essential condition has to be fulfilled. First, the order appeal must be against a judgment, decree or the final order. So, this is the first requirement which has to be satisfied, and such decree, order, final order must be made by the High Court in a civil, criminal or other proceeding. And second, the case must involve a substantial questions of law as to interpretation of the Constitution. And third, the questions must be a substantial questions of law. And fourth, if the High Court under Article 134 clarified that this is a case needs to be heard by the Supreme Court. Now, come to the first regarding the appeal in the constitutional matter. So, as far as the jurisdiction of the Supreme Court under Article 132 is concerned, here the questions must involve interpretation of the constitutions arising out of the any of the proceeding the High Court in the civil, criminal or other proceedings. So, once the questions had assumed such an importance regarding the interpretation of the provision of the constitutions, then such questions require to be speedy determinations, and that is why such kind of the appellate jurisdiction has been conferred upon the Supreme Court by Article 132 of the constitutions by the constitutions maker. Then the question relates to what is the meaning of the civil, criminal, other proceeding. As far as because High Court is empowered under Article 134A that to grant the appellate jurisdictions, grant the certificate of fitness to the party to approach the Supreme Court by way of appeal in the constitutional matter if the case is arising out of the civil, criminal or other proceeding. So, as far the civil proceeding is concerned, it has been interpreted as one in which the person seeks to enforce by appropriate relief for the alleged infringement of a civil right against the other persons or the state, and if the claim is proved, then it would result in express or implied declarations of the right, claim and relief like the payment of debt, damages, compensation, etc. So, if the case arising out of the civil proceeding where person is alleging the infringement of civil right, then it will be case to the civil proceeding. Similarly, the term criminal proceeding has been interpreted means the proceedings where proceeding if it is being carried out to the conclusions, then it may end in death, imprisonments, fine or forfeiture of the property, then proceeding of the High Court must be taken to be the criminal proceedings. And the other important expression which has been used by the Article 132 is that the other proceedings. So, as far the term other proceeding concerns, it has been used in exclusions to the civil and criminal proceeding. So, all the proceedings like the which pertains to the revenue matter like the sales tax, income tax or even the disciplinary proceeding which has been initiated against the chartered accountant, all such kind of proceedings will be covered under the broad purview of the term other proceedings. Now, the other important thing which you have to keep in mind with respect to Article 132 is that what is the meaning of the substantial questions of law. As far the meaning of the term substantial questions of law is concerned, this issue is not being clarified by the Supreme Court because here the court cannot lay down beforehand as to what will constitute a substantial questions of law with respect to the particular case. But here the Supreme Court with respect to this has tried to decipher the scope of the meaning of the term substantial questions of law by saying that if the certain issue is already being decided by the Supreme Court, then such cases it will not be considered as substantial questions of law. But if the issue pertains to such a matter where there is no direct decision of the Supreme Court, and if there is a divergent opinion or if there is difference opinion between the different High Court with respect to interpretations to that particular provision of the constitutions, then such cases it will be presumed to be the issue involving a substantial questions of law and regarding the interpretations to the provision of the constitutions and which has arisen with respect to the civil, criminal or other proceedings, then such case High Court may grant the certificate of fitness under Article 134A of the constitutions, and every party will have the every right to approach the court for the determinations of such a important issue by the highest court of the land. Then the other thing with respect to the scope of Article 132 is concerned, here the party will be entitled to approach the Supreme Court only if the decisions of the High Court would amount to the judgment, decree or the final order. It means if the order is being passed by the High Court, but the suit is still alive, then such case it will not be considered the final order. So, here with respect to the applicability of Article 132 is concerned, here the questions of approaching the Supreme Court on the basis of mere interlocutory order or mere injunctions will not be sufficient. Here what is required that here the High Court has conclusively determined the rights of the party with respect to that particular disputes, and it has finally put to end to the questions. So, once the finality has been accorded by the decisions of the High Court with respect to that particular matters, whether arising of the civil matters or criminal matters or other proceedings, then only in such cases the aggrieved party will have the right to approach the court for the determinations under the Article 132 of the constitutions. Then with respect to Article 132, the other important things which has cropped up before the Supreme Court as to whether the appeal would lie before the Supreme Court with respect to decisions which was given by the single judge, because normally as per the practice of the procedure which is adopted by the court, if any party is aggrieved by the decision of the single judge bench of the High Court, then definitely in that case they may go in appeal before the division bench, not necessarily they may directly try to approach the Supreme Court. So here with respect to this case, the Supreme Court has clarified this issue way back in 1953 in election commissions. Election commissioners was a Venkata Rao case, and in this case exactly the issue before the court was to whether the appeal would lie in the Supreme Court from the decision of a single judge. Here the Supreme Court answered the questions in affirmative by saying that this can be done, but only in very exceptional cases where the direct appeal to the Supreme Court is necessary in view of the great importance of the case and the early decisions of the court is required. So as far the normal rule is concerned, if any party is aggrieved by the decision of the single judge, then they have to go to the appeal before the division bench, and from there if the certificate of fitness has been granted by the High Court under Article 134A, either on the oral applications or even by the suo motu, then they can go and appeal before the Supreme Court. But in case of if the great public importance attached to the case, then such cases here the Supreme Court will be justified to entertain the case directly arising out of decisions of the single judge, as happened in the case of the Venkata Rao. Then with respect to this, here if the certificate of fitness has been granted, then the questions will arise as to what kind of the issue will be entertained by the Supreme Court by way of appeal, whether the aggrieved party will be entitled to rake up the fresh plea before the Supreme Court in the exercise of appellate jurisdictions under Article 132 of the Constitution. With respect to this, the Supreme Court has already clarified that as far the appeal before the Supreme Court is concerned, here the appellant is not entitled to challenge the propriety of decision of the High Court appeal against on the ground other than the ground on which the certificate of fitness has been granted by the court. However, Supreme Court in exercise of its inherent jurisdictions or extraordinary jurisdictions may permit the party to raise a fresh plea, but that can be done only by on the leave of the Supreme Court. So as far because here the Supreme Court is the final court of the land, the highest court of the land. So here the Supreme Court has the solemn responsibility to ensure that any kind of miscarriage of justice is not being carried out. So if something has been altogether not raised before the High Court, but if the party wanted to put such a issue before the Supreme Court, and if do not pertains to the investigation of the fact, it is something which pertains to the interpretation of the provisions of law, then that can be done, but that has to be only with the leave of the Supreme Court. As far even the High Court has been under obligations to grant a certificate of fitness under Article 134A of the Constitution, and if the certificate of fitness is being granted, it does not mean that here the High Court will bind the Supreme Court to hear the appeal. Here the Supreme Court may be justified in the certain cases that just to altogether refuse to entertain the case, even the certificate of fitness is being granted by the High Court under Article 134, if the Supreme Court has come to the conclusion that appeal is not competent or it is not a bona fide. So because if the power has been given to the High Court, then High Court is under obligations to apply its mind. Here the High Court has to delineate, they have to specify as to why this case is such an importance that needs to be heard by the Supreme Court. So if the certificate is being given, then that case also the Supreme Court may refuse to entertain if the if the appeal is not competent, not a bona fide. And other thing which, because what is being provided by Article 134 is that here the High Court is under obligations to grant certificate of fitness either suo motu or on the oral applications of the aggrieved party. But suppose if the High Court is not giving reasons or High Court has altogether refused to give the certificate of fitness, then such case also here the Supreme Court in exercise of its special power under Article 136 of the Constitution, which pertains to the special leave petition, special leave jurisdictions of the court. Here the Supreme Court can grant a certificate of fitness to appeal directly before the Supreme Court if the case has assumed such a public importance and it pertains to the substantial questions of law as to interpretations of the provisions of the constitutions. So, after discussing the provisions of Article 132 of the constitutions, now I am coming to the Article 133 of the constitutions, and as far the Article 133 of the constitution concerns, it deals with the appellate jurisdiction of the Supreme Court in appeal from the High Court in regard to the civil matters. So, if you see the provisions of Article 133 of the constitution, say the appeal to the Supreme Court from decision of the High Court in the civil proceeding, if the certain condition has to be fulfilled. The first is that the decision appeal against must be a judgment, decree or the final order of the High Court in the territory of India, and second, such judgment, decree or the final order should be given the civil proceedings, and third, a certificate of the High Court to the effect that the case involves a substantial questions of law of the general importance, and second, in the opinion of the High Court, the said questions needs to be decided by the Supreme Court. So, as far the Article 133 of the Constitution is concerns, it deals with the appellate jurisdiction of the Supreme Court in the civil matters. So, as far the appellate jurisdiction of the Supreme Court is concerned under Article 133, here this provision was subject to amendment by the Constitution's 30th Amendment Act in 1972. So, if you see the provisions prior to the 30th Amendment 1972, what is being provided before 1972 was that the appeal could go to the Supreme Court in a civil case from a judgment, decree or the final order of the High Court if it is of not less than 20,000 rupees, or that the judgment, decree or the final order involves directly or indirectly some claim or questions respecting the property of the like amount of the value of rupees 20,000, or the case was fit for appeal before the Supreme Court. So, the most significant, so what was happening before 1972 was that in all the matter where the party is claiming the relief of the value exceeding rupees 20,000, in all such cases was going before the Supreme Court as a matter of right. But the very important change which was being introduced by the Constitution's 30th Amendment is that it has altogether removed the conditions of the monetary value, and now appeal could go to the Supreme Court only if the High Court certify under Article 134A that the case involves substantial questions of law of the general importance. So, as far the 30th Amendment of the Constitution concerns, it has given effect to the recommendations which was given by the Law Commissions in its 44th and 45th report. And so, basic object of the Constitution's 30th Amendment was to curtail the number of appeals which are filed in the Supreme Court merely on the valuation test being satisfied, because here the valuation test could not be rational yardstick, and in some of the important questions of law could arise even the suit of the smaller value. So, now the monetary condition has to be this monetary requirement has been removed by the Constitution's 30th Amendment Act. Now, the appeal would go to the Supreme Court in civil case only if the High Court has granted certificate of fitness under Article 134A of the Constitutions. Now, come to the essential requirement for the applications of Article 133 of the Constitutions. Here, as for the applicability of the Article 133 concerns, here if the appeal would go in the civil cases only if the order of the High Court amounts to the judgment, decree or the final order. So, here all these three expressions which was used by the Constitution's maker has different and definite meanings as per the provision of the CPC. So, as far the term final order is concerns, here it has been defined means the order which finally dispose of the right of the party in a suit or a proceedings. Here the term decree has been interpreted by the court as the formal expressions of adjudications which so far as regards the court exercising it conclusively determines the right of the party with regard to all or any of the matter in controversy in a suit, and it may be either preliminary or a final. The term as far the judgment is concerned, as per the provisions of the CPC is concerned, here the term judgment has been used after using the word decree or the final order. So it means the same thing as the decree or the final order, but as far the term judgment is concerned, as per the provision of the CPC, here the judgment is the statement of reasons given by a judge on which the decree or order is based. So here what is happening in the proceeding of the court is that the court first provide the decree or the order, and after a few days the court come out with the judgment. So in the judgment, court lay down as to what are the reasons, what are the factors, or what are the provisions of the law which was being considered by that particular court on reaching that particular interpretations of the provisions of law, and how they have determines the right of the parties. So as far this provision is concerned, here the one thing you have to keep in mind regarding this provision, that the Supreme Court will exercise the appellate jurisdictions under Article 133 of the Constitution if the order of the High Court amounts to the final order, decree or judgment. So it has put a finality to the claims of the party and finally decided to dispose of the case. So as far the term civil proceedings or the civil proceedings or criminal proceedings is concerned, civil proceeding under Article 133 is concerned, here the term civil proceeding has the same meaning as being interpreted under the Article 132 of the Constitution. So it means here the party is asserting the infringement of their civil rights, and if the case is been decided, then definitely in that case it may lead to the relief or claim which has been claimed by the party. So now I am coming to the other important thing with respect to the Article 133 of the Constitution, that the substantial questions of law of the general importance. So now again the question will rise to what will we consider the substantial questions of law of the general importance. Here this issue is not being decided by the court, but the Supreme here we again have to rely on the previous interpretation which was given by the court as to if on particular point if there is no direct decisions of the court, and if there is a divergence of opinion between the different high court with respect to interpretation of any provisions of the law, then it will be considered as the substantial questions of law. So as far the applicability of the Article 133 of the Constitution is concerned, here what is required, what is necessary, that it must involves a substantial questions of law of the general importance. So if you compare with the Article 132 and 133, so with respect to the Article 132 is concerned, it pertains to substantial questions of law as to the interpretations to the provision of the Constitution. But under Article 133, what the expression which has been used by the Constitution maker is that the substantial questions of law of the general importance. So the third important thing which you have to keep in mind with respect to Article 133, that here the High Court has to grant a certificate of fitness under Article 134A of the Constitution with respect to the civil matter also. So as far the opinion of the High Court is concerned, here while giving the certificate, the High Court must be of the opinion that it must involve a substantial questions of law and it needs to be decided by the Supreme Court. So as far the power of the High Court regarding the expressing opinion is concerned, here this is the discretionary power of the High Court, but this discretionary power of the High Court needs to be exercised only with respect to the certain well-known principles, and so this discretion is concerned, this is a judicial discretion, and it has to be applied only by the interpretations to the provisions of law. So if the court has decided to give the certificate, or court has decided to refuse to give the certificate to appeal before the Supreme Court under Article 133 by saying that, then that case it is obligatory on the part of the High Court to give the reason as to why this case needs to be appealed before the Supreme Court, or why this case do not require to go before the Supreme Court in the exercise of appellate jurisdictions in the civil matter. So as far the certificate of the High Court is concerned, if the certificate has been given, and if that certificate, if the court has not clearly clarified as to whether this case needs to be heard by the Supreme Court under Article 133 clause 1 subclause A, B or C, or if the Supreme Court has not given any reason as to why this case is fit for the appeal, then that case the Supreme Court will be justified to quash the order of the High Court by saying that the certificate which was earlier given was defective nature, because here the High Court has not clearly spelled out as to this case is of the substantial question, involve the substantial questions of law of general importance, and it pertains to the which of the clause of the Article 133 clause 1. So it is obligatory on the part of the High Court as to they had to clearly mention as to this case needs to be heard under which provisions of Article 133 clause 1 sub clause A, B or C, or if they are refusing to give the certificate of fitness, then that case also here they have to specify the reasons. Then in civil matter also the issue which has crop up before the Supreme Court as to whether civil matters, whether it would be appropriate for the aggrieved party to raise a fresh plea before the Supreme Court for the first time, which was not earlier raised before the High Court. With respect to this, the Supreme Court has already clarified that ordinarily the Supreme Court does not allow the fresh plea to be raised in appeal, but we had the instances where the Supreme Court has entertained such a fresh plea, and one of the case is the Bombay Municipality versus Advanced Builder case in 1972, where the Supreme Court entertained a new plea and remanded the case to the High Court for its view on the, because the plea went to the root of the case. And also we had the case of T.K. Pandit versus P.K. Chatterjee, where the Supreme Court held that the new plea on the pure questions of law not involving any investigation of fact can be raised for the first time in the Supreme Court. So Supreme Court would interfere in the finding of the fact by the High Court only when there is a grave errors in exercise of power by the High Court. So the other things which pertains to Article 133 is that to whether in such case whether it would be appropriate to just to go in the appeal in the civil matters under Article 133 against the decision of the single judge. Here with respect to this, in one of the case, that is SC Bank Kanpur versus Bhagwan Das, way back in 1965, the Supreme Court said that no appeal shall lie to the Supreme Court from a judgment, decree or the final order of the single judge of the High Court. However, as far as this provision is concerned, this provisions may be removed by the law made by the Parliament under this article. So here as far as the Article 133 clause 3 is concerned, here the Parliament has been given power. So in that case, if the Parliament has provided otherwise, then such case if the appeal can go to the Supreme Court under Article 133 against a judgment, decree or the final order of the single judge of the High Court. So this is the way how Article 133 of the Constitution has been interpreted and how the scope has been deciphered by the court. Now coming to the appellate jurisdiction Supreme Court in the criminal matters, and it is being provided by the Article 134 of the Constitution. So if you see the provisions of Article 134 of the Constitution, it says that here by these provisions a limited criminal appellate jurisdiction is being conferred on the Supreme Court by Article 134. So as far the appellate criminal jurisdiction concerns, here the appeal would lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding the High Court in two ways. First, here the certain case, here the appeal would go to the Supreme Court without a certificate of the High Court under Article 134 clause A, sub clause A and B, and second case where the appeal would go in the criminal matter before the Supreme Court with a certificate of the High Court under Article 134 clause A, sub clause C. So now I am coming to those cases where the appeal would go to the Supreme Court without a certificate of the High Court. So as far as without a certificate of the High Court is concerned, here appeal would lie to the Supreme Court if the High Court reverses the decisions of the acquittal of the accused persons and sentence him to death. So what it means? It means suppose if the case is being heard by the session judge, and if the session judge acquit the accused of the charge of the murder, and if there is a government makes an appeal against the judgment of the session judge to the High Court, and the High Court set aside the order of acquittals and sentence the accused persons to the death. So, in such case appeal would lie to the Supreme Court under Article 134 clause 1 subclause A. So, now the other important things which will come regarding as to what is meaning of acquittal, whether the acquittal would amount to the complete acquittals or complete exonerations of the accused from that particular charge, or acquittal has altogether a different meaning as per the provisions of Article 134 is concerned. Here the term acquittal has been interpreted by the court by saying that acquittal does not means the trial must have ended in the complete acquittals, but would include the cases where the accused has been acquitted of the murder and has been convicted of a lesser offence. So, if the suppose accused person being charged for the offence of murder under article under section 301 of Indian Penal Code, and after the hearing the case, if the instead of the punishing the persons under the section 302 of Indian Penal Code, if the court had decided to punish him under the section 304 where the case of the culpable homicide not amounting to murder, then here such cases where the court had decided to acquit the person from the charge of murder and they have decided to punish with the lesser punishment, then such case also here the appeal would go to the Supreme Court under Article 134 clause 1 subclause A of the Constitutions. Here so as far the appellate jurisdiction of the Supreme Court under Article 134 is concerned, here once it has been established that the High Court has applied the correct principles in reversing the order of acquittal, then definitely in that case the Supreme Court would not ordinarily go for the order of the convictions to reassess the entire evidence, because as far the criminal jurisdiction of the Supreme Court under Article 134 is concerned, here the Supreme Court is not expected to exercise jurisdictions by simply acting as a court of scrutiny. So, Supreme Court cannot act as a court of scrutiny for the High Court, and every criminal cases where the person has been acquitted or if they have been punished for the lesser offence, then by way of right the Supreme Court will entertain such appeal. So, the other important case where the appeal would go to the Supreme Court under Article 134 of the Constitution concerns, that is being provided by Article 134 clause 1 subclause B of the Constitutions, and what is being prescribed by this provision that if the High Court has withdrawn for trial before itself any case from any court subordinate to its authority, and in such trial convicted the accused persons and sentenced him to death. So, in such cases appeal shall lie to the Supreme Court from the order of the High Court. So, first case where the Supreme Court has where the High Court has reversed the finding of the Session Court and convicted him for the or sentenced him for the offence of death, then that case appeal would go to the Supreme Court. The other contingency where the case would go to the Supreme Court in the criminal matter under Article 134 without the certificate of the High Court, if the High Court has taken up the case from the court subordinate to its from the session judge, and they have altogether sentenced such convicted the persons and sentenced him to death. So, in both these contingency appeal would go to the Supreme Court without a certificate of fitness which may be provided by the High Court under Article 134 A of the Constitutions. Then the other contingency where the appeal would go to the Supreme Court is with the certificate of the High Court. So, as far with the certificate of the High Court is concerned, here appeal would lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of the High Court, if the High Court certify under Article 134A that case is a fit one for appeal to the Supreme Court. So, as far this subclause C is concerned, all the High Court has been given power to give the certificate of fitness, but as far the proviso to this provision concerns, here the such appeal would be subject to the rules which may be made by the Supreme Court under Article 145 of the Constitutions, and such other conditions which the High Court may establish or required. So, as far the certificate of fitness concerns, here it will be subject to the rules which the Supreme Court is empowered to make under Article 145 of the Constitutions. So, as far the criminal jurisdictions of the Supreme Court with a certificate is concerned, with respect to this the Supreme Court has already deciphered the scope of these provisions in Nar Singh versus State of UP in AIR 1954 Supreme Court case, where the Supreme Court said that the power of the High Court to grant fitness certificate in criminal case is a discretionary power, but this discretion is a judicial one and it must be judicially exercised along with the well established principle which governs those matters. So, certificate cannot be granted by High Court merely on the questions of fact, because as far the criminal law is concerned, here the every person is presumed to be innocent unless proved otherwise. So, it is for the public prosecutor to prove the guilt of the accused person beyond doubt, and it is only after clearly scrutinizing all the facts and evidence, here the Supreme Court will decide to award him one sentence or other. So, if there is any thing which pertains to the if any doubt arises with respect to the facts or evidence, then definitely in that case benefit will definitely be given to the accused person. So, as far the questions of fact is concerned, here if the it pertains to the doubt, in that case they will be entitled to claim the benefits. So, questions of giving certificate for the appeal before the Supreme Court would not arise if it pertains to the any dispute pertains to the fact or evidence which are admitted before the High Court when it was dealing with the such case. With respect to this, the Supreme Court has further clarified in the Uma Narayan versus K. Carson's case in 1971 by saying that the concurrence finding of the two court below, if it is not tainted with any infirmity, are binding on the court. So, if the certificate of fitness be granted, but if there is a concurrent finding and if the Supreme Court by the preliminary scrutiny has come to conclusion that it is not suffering from any kind of infirmity, then definitely in that case the Supreme Court may refuse to entertain the case under Article 134 of the Constitution. So, now I am coming to the Article 134 clause 2 of the Constitution, and it empowered the Parliament to enlarge the appellate jurisdictions of the Supreme Court in regard to the criminal matters. So, in exercise of this power, the Supreme Court has already enacted the Supreme Court Enlargement of the Criminal Appellate Jurisdiction Act 1970, and if you see the provisions of the sections 2 of the 1970 Act. So, what is being prescribed by this Act is that without prejudice to the power conferred on the Supreme Court by clause 1 of Article 134, here an appeal shall lie to the Supreme Court from any judgment, final order or sentence in criminal proceedings of a High Court in the territory of India, if the High Court first has on appeal reversed the order of acquittals of the accused persons and sentenced him to the imprisonment for life or imprisonment for a period not less than 10 years. And second, if the High Court has withdrawn for the trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused persons and sentenced him to the imprisonments for life or imprisonments for a period not less than 10 years. So, as far the appellate jurisdiction of the Supreme Court with respect to the criminal matter is concerned, here the aggrieved party is entitled to approach the court without a certificate of fitness which may be granted by the High Court under Article 134. If the High Court has reversed the finding of the subordinate court, or the High Court has taken the case and sentenced him to death. The other case where the appeal would go with the certificate of fitness by the High Court under Article 134, that if the High Court has reversed the order of acquittals and decided to imprison such persons for the life or sentence him for the imprisonments for not less than 10 years, or second contingency that where the High Court has withdrawn the case for trial before itself, and in such trial sentence such accused persons for the life imprisonments or for the imprisonment for period not less than 2 years. So, as far this provisions concerns, here if the accused person has been convicted for the offence under the section 302 of the which pertains to which provide punishment for the offence of murder, they can prefer the appeal to the Supreme Court as a matter of right, but in the appeal by the special leave under Article 136, the Supreme Court as far this power of the Supreme Court is concerned, here the Supreme Court does not take the exercise of the re-appreciating the entire facts, entire evidence. Here the Supreme Court will only try to entertain the interpretations to the provisions of the law, and the Supreme Court will try to see as to whether the High Court has correctly approached the case, and they have decided to apply the appropriate provisions of law or not. So after that, if the Supreme Court has come to the conclusion that the Supreme Court has some doubt regarding that, the Supreme Court can refer the case to the High Court back for their clarifications with respect to the such matters. So after discussing these provisions, now I am coming to the certificate. As far the certificate of fitness concerned, this provision is already being clarified to you with respect in context of interpretations to the provisions of Article 132, 133, 134 of the Constitutions. Now I am coming to the other important jurisdiction of the Supreme Court, which was being conferred upon it by the Article 136 of the Constitutions. And Article 136 of the Constitutions deals with the special leave petitions or special leave jurisdiction of the Supreme Court. And if you see the provisions of these provisions, they say that it conferred a special or residuary power of the Supreme Court, which is exercisable by the Supreme Court outside the purview of the ordinary law, and where the justice demands the interference by the highest court of the land. So as far the article provisions of Article 136 is concerned, here the Supreme Court has been given the plenary jurisdictions in the matter of entertaining and hearing appeal by granting special leave against any judgment, decree, determinations, order, sentence in any case or matters passed or made by the High Court or tribunals in the territory of India. So as far the provisions of Article 136 is concerned, here the Supreme Court has been given this special jurisdictions, or the Supreme Court has been given the extraordinary jurisdictions or residuary jurisdictions with respect to the any judgment, decree, determinations, order, sentence. So as far the Article 136 is concerned, here if you compare these provisions with the Article 132 to 135 concerns, here in the previous provisions, here the Supreme Court was entitled to entertain the appeal, or Supreme Court was empowered to hear the appeal only if pertains to the civil, criminal, other proceedings, and it pertains to the final order, decree or judgment. But as far the Article 136 concerns, it is not confined merely to the judgment, decree or the final order, but it also includes any kind of determinations or sentence, and there is no need that it should confine only to the civil, criminal, other proceedings. Here it extends to the any cause or matter. So you see the scope which the extraordinary jurisdiction which has been conferred upon the Supreme Court by the Article 136 is concerned. So any cause or matter which has been decided by the Supreme Court in any court or any by tribunals, then such case the Supreme Court exercises special appellate jurisdictions. So as far this provision is concerned, here the term any proceeding exercise of power, here it is left entirely to the discretions of the court and unfettered by any restrictions, and this power cannot be curtailed by any legislative approach except the amendment of the provision of the Constitutions. So as far the Article 136 clause 2 is concerned, here this power of the Supreme Court, as far the special leave petition is concerned, it cannot be applicable with respect to any judgment etc. of the any court or tribunals constituted by or under any law related to the armed forces. So first come to the as to what are distinctions between the Article 132 to 135 and Article 136 of the Constitution. As far the Article 132 to 135 is concerned, here the appeal can be entertained by the Supreme Court only against the final order. But as far the Article 136 is concerned, here the word order is not qualified by the word or by the adjective final. So the court can grant a special leave to appeal even from the interlocutory order. So you can see the first difference is that with respect to Article 132 to 134, it has to be only against the final order, but under Article 136 it may be even against the interlocutory order. Second important difference which you can notice with respect to this provision, that under Article 132 to 134 appeal would lie against the final order of the High Court, but under Article 136 the Supreme Court can grant a special leave for appeal from any court or tribunals, so from any subordinate court below the High Court, even without following the usual procedures of the filing appeal in the High Court or even where the law applicable in the to the dispute does not make a provision for such appeal. The third important things which you can notice with respect to this provision, that the under Article 132 to 134, appeal can lie to the Supreme Court only against any judgment, decree, determinations, etc., but under determination by any court. But under Article 136, appeal can lie against any case or any matter. So definitely the scope of Supreme Court jurisdictions under Article 136 is concerned, it is much wider. So as far the applicability of this provision is concerned, here the by this provisions, here the Supreme Court has been given this power to grant a special leave to appeal both in the civil and criminal cases. And but the one important thing which you have to keep in mind with respect to this provision is that the determination or order which sought to be appealed must have the character of judicial adjudications. So as far this provision is concerned, if the matter pertains to the purely administrative or executive discretion, then definitely it cannot be subject matter appeal to the Supreme Court. And the other important thing which you have to keep in mind with respect to the interpretation of provisions of Article 136 is concerned, here the authority whose act is complained must be the court or tribunals. So as far the scope of the Article 136 is concerned, here the nature and scope of Article 136 is being deciphered by the Supreme Court in various cases, and you can see the case of DC Mill versus Commissioner of Income Tax West Bengal way back in 1955, where the Supreme Court had clarified that it is being an exceptional and overriding power, and it has to be exercised sparingly and with cautions, and only in the special extraordinary situations if so warrant. And this was being further clarified by the Supreme Court in Variety Emporium versus R.M. Muhammad Ibrahim case, where the Supreme Court said that it normally does not interfere with the concurrent finding of the trial court and the High Court unless there is a sufficient ground to do so, but it does not mean that the injustice which was injustice must be perpetuated because it has been done in 2 or 3 times in a case. Therefore, if the appellant prove that the concurrent decision of the 2 or more court or tribunal is manifestly unjust, then it will be the duty of the Supreme Court to remedy such injustice. So as far this provision is concerned, here if there is concurrent finding, but if the Supreme Court has reached to the conclusion that it is something which may lead to the manifest miscarriage of justice, then that case the Supreme Court may think of the exercising its extraordinary jurisdictions by granting special leave to appeal before the Supreme Court. And the other thing is that the special leave jurisdiction of the Supreme Court is concerned, it has been subject to the various rich interpretation of the Supreme Court with respect to the criminal matters. So I think the time is not. Okay, I will continue this part in tomorrow.
Right. Of course, viewers, we shall be continuing this in our lecture tomorrow. So with this, first of all, thanking sir for being here. Thank you so much, sir.
Thank you.
And for the very interesting and wonderful lecture that we had today, very informative for the students. So with this, friends, we bring the lecture to a close, and thank you so much for watching. Have a great day.